Director at Homeline, and joining me today is Homeline's Managing Attorney and Hotline Director Mike Braw, and Rachel Sterling, Homeline's COVID-19 Eviction Response Coordinator and Housing Attorney. And you're joining us on Wednesday, September 22nd in the afternoon for another one of Homeline's Eviction Moratorium phase-out webinars. Again, this week we're going to just be doing a general overview again, like similar to last week, if you joined us, and we'll have plenty of time for questions. I don't think we got a lot of questions submitted in advance, so if you have questions, please send them in. But we'll go through some quick slides here, and Mike will do an overview, and then we'll get to the questions a little bit later. Yeah, Homeline is a statewide nonprofit organization. We provide free and confidential legal advice to tenants, and in English, Spanish, and Somali and Hmong languages. We have a staff of 28, and we've advised over 270,000 renters since opening. There's our hotline number and our website where you can email an attorney directly. And of course, we still continue to maintain some information on our website about the eviction moratorium phase out. We'll throw the links in the chat as well. There's also, excuse me, links to future webinars, registration, and recordings of our previous seminars, like the one last week. And here are the upcoming webinars that we have scheduled beyond today. Next Wednesday, referee hoteling from the 4th Judicial District Court, the Housing Court referee will be joining us to talk about what Hennepin County, that's the 4th Judicial District, what they're doing in the courts to respond to eviction cases filed during the phase out, and how they've prepared different calendars for addressing the evictions that are being filed. So we'll hear from her next week.
Excuse me, Eric, kind of underselling referee hotelling's role. She's sort of the lead referee in the most populated county in the state, and she focuses on housing court. So yeah, there's not one judge that's in charge of evictions throughout the state, and she's not technically a judge, but she's among the most important judicial officials, if not the most important judicial official when it comes to evictions in Minnesota. So very much so looking forward to her joining us next week.
And I'll put a link in the chat for the how you can register for that one directly in just a minute here. But then the following week, the first Wednesday in October, Dan Hilton from Housing Link, who I believe is their research director, is going to join us to talk a little bit about the some of the research they've been doing, studying trends in the rental market during the pandemic, the moratorium, during the phase out, and looking at what's happening in the rental market related to that. And then, of course, the next phase in the eviction moratorium phase out is on October 12th. So just the day after that, on the 13th, we'll be hosting another session to talk through some of the details of that and answer questions. And again, we always want to reiterate kind of the key rental assistance programs for folks that are joining us and aren't aware of them yet. Hopefully that you're aware of them. But Rent Help MN statewide program these three that we're going to talk about really quickly here on your screen are eligible programs under the eviction moratorium phase out in Minnesota. So it helps if you've got a pending application at one of these. It helps protect you against eviction for non-payment. So that's the statewide program, renthelpmn.org. There's the landlord initiated application initiated by the landlord program in Dakota, Hennepin, and Ramsey County Zero Balance Project. And then lastly, there is a separate Ramsey County program. So residents of St. Paul and the rest of Ramsey County can go directly to this program. And we understand that it's a quicker potential quicker turnaround for applications than if you're going through Rent Help MN. So with that, I will, I'll, like I said, post a couple of those links in the chat, and then a reminder, we only have a handful of questions submitted in advance, so please, we prefer you use the question and answer Q&A button on Zoom to submit your questions, and we'll tackle some of both Rachel and Mike will tackle those after this presentation. So I'll hand it over to Mike.
Thanks, Eric. And absolutely encourage questions to come in. I've got about maybe half an hour's worth of stuff that I want to talk about today. And then we're going to be turning it over to what you want to talk about. So we can't do that unless your questions come in, put them in the Q&A slot. Hope to see lively questions and conversations so we can make this a good use of everybody's time. Okay, so let's start by talking about when evictions will be filed again in Minnesota. Can you roll the slide, Eric? Thank you. So this is sort of a misleadingly titled slide. Evictions have been filed in Minnesota since the pandemic began. Just the volume of evictions has gone down very substantially. When I think about evictions being filed in Minnesota, what I'm really thinking about is non-payment of rent evictions. And the reason why I think that way is because that's almost every eviction in Minnesota. At least it has been historically. Well over 90% of evictions, certainly during my career, so in the last 25 years or so, have been for non-payment of rent in Minnesota. That's just the system that we have. It's how it's designed, and that's why landlords, when they're filling out an eviction form, that's the box they check instead of a material breach where the tenant's done something wrong, like having a dog, or holding over where the tenant was supposed to leave by a certain day and didn't leave. Those are the other primary reasons why landlords file evictions. It's non-payment of rent that is the real reason why landlords file. And that's the question we've been trying to answer for people since we started doing these webinars last April. I don't know how many we're up to, 60, 61, 65, somewhere in there of these sessions that we've done. When we began, they were 2 times a week, and then we did them once a week, and then sporadically whenever new information came out. But we've been doing them this fall, and we plan to do them through the final phase coming next month in October, and maybe more. Because we still get a lot of questions about this, and we still get a lot of people tuning in to watch and see what the latest is. So to recap what happened, if in case this is news to you, for about 15 months or so, landlords were not allowed to file evictions for non-payment of rent or for many other reasons. There were some exceptions built in. It was generally referred to as an eviction moratorium. That official moratorium was tied to some executive orders that the governor issued through the peacetime emergency. Basically, it was 16 months total. That's over. The peacetime emergency is over. The eviction moratorium tied to the peacetime emergency is over. What took its place, though, was what we refer to as a session law, which isn't that different than a statute, except that this has a built-in end date on it. The session law does, but it took effect June 30th. So I guess for almost 3 months into the phasing situation that we're going to be talking about in depth in a second. In fact, let's roll over to the next slide if we could, Eric, and punch us up to where we should be shaded to by now, if you could. There we go. So what's been happening with these phases? First of all, we label them phase 1, phase 2. That's our labeling. It's not something built into the session law or the statute, however you want to think about that law. We just decided to call it that to make it a little easier for everybody to use the same information when they're talking about things. But what's been happening steadily since June 30th is landlords have been reaccumulating rights that they used to have prior to the pandemic. So we're trying to, by this phase out process, get back to what the law was in February of 2020, basically. That's what we're step by step incrementally getting back towards. And I say landlords reaccumulating rights because it's pretty much what happened is landlords lost the right to do many things that they normally were able to do back in February 2020. The governor's immediate eviction moratorium in March of that year was designed to make sure that tenants were able to stay in their homes, even if they couldn't pay their rent. And so landlords were the ones that lost rights during the peacetime emergency when it comes to landlord-tenant issues. They did gain a couple things, I suppose, if you're looking at some of the rules that happened throughout the tenure of the peacetime emergencies. But in general, it was landlords forfeiting rights, and now they're getting them back. So how this has been working is starting on June 30th, the landlords reaccumulated a bunch of new rights. Then they got more rights on July 14th. They don't lose the ones they got on June 30th, right? They keep those. They just add the new rights that they got on July 14th. Then on August 13th, a new batch of rights got re-added to the landlord's toolbox. And on September 12th, just a couple of weeks ago, the landlords got another very meaningful tool in their box. The latest phase, phase 4, as we're calling it, allows a landlord to now file an eviction for a tenant who's behind on rent, who's ineligible for COVID-19 emergency rental assistance. So you'll notice that that's a different phrasing than what we had in August, where it said that the landlord could terminate leases for a tenant that wasn't eligible. So a termination of a lease isn't the same as an eviction. It sounds the same. It sounds very similar, at least. An eviction means a court case. They used to be called unlawful detainers or UDs. Some people still refer to them as that. But an eviction means a court case filed by the landlord, $300 the landlord has to pay roughly to start the court case, where they're going to be asking the court to ultimately remove the tenant. That's really what happens in an eviction is the landlord is saying, hey, judge or referee, please remove this tenant from my property. They aren't complying with parts of the lease, or they haven't paid the rent or something like that. And that's what they're asking the court to do, is to intervene and give possession to the landlord who had possession before the tenant moved in originally. So landlords can now file evictions, like I said, for a tenant that's ineligible for the rental assistance. And we'll talk in a second, in a few slides, about sort of the impact that new phase has had, what kind of volume we're seeing. But we should look forward to the other two phases that still are not shaded yet. So we have phase 5, which happens on October 12th. Easiest way I can explain what happens on October 12th is the landlords at that point have every right that they had back in February 2020, except for they can't file or continue with an eviction if the tenant has a pending application in with a place like Rent Help MN or one of the other programs. So that's the only remaining peacetime emergency eviction moratorium related barrier left for the landlord. I think the biggest new right that a landlord gets on October 12th is that they can suddenly now start non-renewing leases or giving notices to vacate, which was, again, the rule back in February of 2020. Again, not the same as an eviction, simply not renewing a lease, very different. And right now, a landlord can't simply do that for the sake of doing it. It's not something that's allowed, but they will be able to do that once again on October 12th. So that is an important phase change. There's another one in a second that I'll talk about on the next slide as well. But then once we move past October 12th, tenants are still going to be protected all the way through, and this isn't a typo, through June 1 of next year, June 1, 2022, if they have a pending application in with a place like Rent Help MN. The theory behind this length of protection, which was a heavily negotiated agreement between both the Democrat-controlled Minnesota House and the Republican-controlled Minnesota Senate, and the governor, a Democrat as well. The reason why this really long distance protection was kept in place was a recognition by everybody involved that the tenant might not be able to get money quickly enough through Rent Help. It was already known late June that Rent Help money wasn't going out as fast as I think everybody had hoped it would be going out. And it still isn't going out as quickly as everybody has hoped, but it is going out. Money is going out the door to landlords to get tenants caught up on their rent. But it takes time, and what we don't want to see is a tenant evicted for non-payment of rent right now. And the landlord, we want them to get their money as well. We want landlords to get paid for what the tenant owes. And that money is already in the state's coffers. They have possession of the money. It's not theoretical money. We're not hoping for some new legislative agreement to occur. This is money that came from the federal government that has been allocated already. And Minnesota already has it. It's just a matter of getting it to the landlords based on the process that the tenant and or landlord has to go through to qualify for the money. Eric mentioned the three main programs, the Rent Help Minnesota, the Zero Balance Project, which is just a few counties in the metro area, along with the St. Paul specific tenant initiated application process. And so anyhow, those are the ways that tenants could try to get this money ultimately to the landlords to settle their balance that they owe. All right, let's go on to that next slide, and we'll talk about the other notable key component of the October 12th change. So at present, right now, a landlord is allowed to file a non-payment of rent eviction for a tenant who's ineligible for COVID-19. They already were able to file an eviction for a tenant who refused to apply or refused to help the landlord apply, basically, or stood in the way of applying. But this September 12th allowance where the landlord could file for a tenant that's ineligible was a much bigger and more important deal. But even in that case, even if we have a tenant that was ineligible for the COVID-19 assistance, the landlord still does have to give a 15-day notice before they can file the eviction right now for non-payment of rent. Now, this is something that we don't have in Minnesota. Almost every other state does. But in Minnesota, there's no requirement that a landlord give any warning at all to file a non-payment of rent eviction. I'm talking February 2020 rules here. Yeah, if the tenant's rent is due on the 1st of the month, the landlord could go down to the courthouse on the 2nd of the month and go file an eviction. There's no law that stops the landlord from doing that. Does that happen a lot? No, but it does happen. Landlords sometimes do file that quickly. They have the right to. There's no requirement that they give any warning at all. There simply isn't. And so this is a big change. This 15-day notice requirement, again, part of this heavily negotiated agreement between very differing political parties, required a 15-day notice. And this 15-day notice had to have a few key components to it. The first thing it had to say was, hey, look, tenant, I can evict you now, right? I know that you've heard about the eviction moratoriums, maybe the federal one, maybe the state one, and you're wondering, hey, can a landlord ever evict me? Well, now I can. So the notice has to say the moratorium is over. I have the right to evict. It also needs to say how much the rent is that's due. Now, if I'm a landlord giving one of these 15-day notices, I'm not going to limit it to the rent. I'm going to put everything the tenant owes. Maybe there's some utilities that are paid by the landlord, but then they get passed on to the tenant. Maybe there's some late fees as well. I would include everything because you want this to be as official as it can be, because the tenant might be using that to apply for rent help. Because one of the other things that has to be in the notice is information about where to apply for rental assistance. Because that's really what we want to have happen here. We don't want landlords to need to file evictions, spend their $300 to get an empty place. That's really what a landlord gets if they win an eviction. What we want to have happen is that tenants are spurred on to trying to get this rental assistance. You'll have to trust me on this. Not every tenant knows about this. You might think they do. You might think that everybody should have heard about this by now, but it simply isn't true. We talk to people all the time that you have to tell them, oh, did you know about this rent help? I'm not sure what you're talking about. Can you tell me more? And they're being very sincere. There's been so much information in the last 15 months, 16 months. A lot of it's useful, really good information, and some of it's just so dizzyingly hard to figure out which stuff applies to who. Honestly, it's one of the reasons why we started doing these, why we still do these. I mean, these free sessions where landlords, tenants, social workers, city officials, sometimes court officials stop by to see what we think the most current version of the rules that apply to Minnesota specific landlord and tenant issues are, because it is confusing. And that's one of the reasons why this notice is required. Here's how much you owe. I can file an eviction now, just so we're clear. And you should go apply for money if you haven't yet, because, hey, we want to get paid as the landlord, and we know that you want to get this money sent to us if possible, tenant, because then your record will be fairly clean. You won't get an eviction, hopefully, and your debt will be settled. So anyhow, that's the notice requirement. That's no longer going to be in place after October 12th. So that's another key component of the October 12th phase 5, as we're calling it. Okay, let's talk briefly about this. I've mentioned it already, but that safe harbor for tenants, where if they've applied and they have a pending application, that's the actual term of art here. If they have a pending application, then the landlord can't file an eviction and they can't proceed with an eviction. It's clearly stated in the session law that those are two different things. Initiating or proceeding are not the same things, and they're separated, so they have to mean something separately. So I think that any tenant during an eviction process, the landlord's already filed the case. If they file and they've got a pending application, it should pause or stay. I'm not exactly sure what phrase a judicial official will use, but it should pause or stay the eviction at that point, at that moment in time. And so that's a very important and long-lasting bit of protection, and the last protection offered by the phase out / off ramp that we're all dealing with going forward. Okay, let's talk about whether phase 4 mattered. Those of you that have watched a few of these sessions, and I know that we have a lot of repeat viewers, and we certainly appreciate that. I'm always happy that you're finding some value in these presentations. One of the things we've talked about is that phase 4 was a big change. Phase 3, the one in August, I think I probably, if phase 3 had feelings, I'm sure I hurt them by saying that phase 3 didn't matter that much. And I said that several times on many of these sessions. But phase 4 was a much more meaningful and important phase. And let's see if it had any real impact. So what we did is we looked at the evictions that were filed for the work week prior to phase 4 starting. So this would have been September 6th through the 10th. The 6th was a Labor Day, so there's going to be a few less evictions filed that week in theory, but there were 64 evictions filed statewide that were residential evictions. It's a little bit confusing sometimes when you look at all the evictions that are filed throughout the state. The last part of a foreclosure is an eviction, for instance. Also, if somebody that doesn't pay their rent in a strip mall gets evicted, it's also filed as an eviction. So you have to look at each case to see, wait a second, is this a residential eviction? And you can generally tell, but you have to look at them to know. Anyhow, there were about 64 evictions filed statewide in that week prior to phase 4. The following week, which admittedly had 5 business days instead of 4, there were nearly twice as many, 125 evictions filed statewide. Now, this isn't a flood of evictions. It's double, right, the week before, so that's meaningful. But if you just look at, all right, use 16,000 evictions filed roughly annually in the pre-pandemic years. So that's about 300, 250 to 350, let's say, per week would be the average weekly filings of evictions in a normal year. So we're still less than half of that. Now, one of the things that we have talked about, if you went back and watched all of our sessions, we had a couple fairly early on. We didn't know it was early in the pandemic. We didn't know how long things are going to last. Where we talked about a wave, a tsunami, a surge in evictions. And that was all based on this concept of tenants owe a lot of money. That was when people were still talking about rent strikes really actively, about simply not paying. Not that landlords would get the money from the government eventually, just that they shouldn't get paid at all. A lot more movement in that direction at that time. But the notion that there was going to be what, $600-700 million floated from the federal government to help tenants get current on rent in Minnesota alone seemed a little bit fantastical as far as a reasonable estimate back in July or August of last year when we were talking about those sorts of predictions. Yeah, giant wheelbarrows full of money solve a lot of problems. And as I've talked about today, and every time I've done one of these presentations, landlords file evictions because of money. And so if money will solve the problem, that's the reason why we're not seeing the surge in evictions. This is still more. There's no question that we're seeing an increase. We're going to see more activity in October when landlords have new rights as well. There's no question about that in my mind. But the reason why we're not seeing wave after wave, that number isn't 1,000 or 5,000 or 10,000 evictions in 1 week when landlords got this new right, is because landlords are confident that the money's real. They're impatient, and I don't blame them for that, but they figure that the money's coming eventually. And so that's why the eviction surge hasn't happened. You could say that our predictions were terrible or completely off base, but again, we had no idea that this was going to be this kind of money coming from the federal government, which is good news. When nobody wanted the surge in evictions, so not a massive spike, but still a meaningful increase in the number of evictions that landlords are filing with the phase 4 changeover. So a question that we get fairly regularly, if we could go to the next slide, is what's a pending application? Because that's what we need for protection all the way through June of next year. So a pending application, we got some definitions here. It's been submitted and has not been denied, withdrawn, or paid. Okay. An incomplete status isn't the same as pending. So that's one where the tenant is supposed to get perhaps more information, or maybe the landlord needs to provide some information. But an incomplete status is not the same as pending. So if payment is deemed ineligible, there will be an update in the system with a written denial notice sent to the tenant. Tenant might be able to reapply at some point or appeal. And during the appeals process, the application is considered pending. This is going to be increasingly important, as that's the only protection that's left meaningfully starting seriously in October. It's already sort of started now, but on October 12th, it's going to be much more severe. Landlords won't be required to give a notice anymore. And I think that there's going to be an increase in evictions from October 12th going forward, even though many landlords are already regaining the right to file already. All right, on to the income eligibility here. So another question that people will ask is, well, who's ineligible? Why will people be ruled ineligible? And this is, I think, probably the most common reason why a tenant would be ruled ineligible is that they're over the income levels. So this is a county by county question. It's not districts, it's not cities that you're looking at, it's county by county analysis. And I realize that Minneapolis is not the same as Independence, Minnesota, a very small city in Hennepin County, or Medina, or one of the other small, very sparsely populated cities in Minneapolis. And Edina is not the same as Minneapolis as far as the average income, but these are county by county analysis that we're looking at. And so the highest income eligibility is places that I guess you'd probably guess, mostly metro counties. The lowest area median income is much less densely populated counties, most of them, again, where you wouldn't find a lot of people. And then there's a lot of counties in between. So there's a lot of different levels. There's a couple different numeric examples. If you've got a family of 4, up to almost 80,000 in the metro area counties, and then just under 60,000 in the least densely populated counties. And then the range, I think I remember looking at this last week, 8 or 9, maybe even a dozen different levels that had been declared by the by the system that we're using as to the area median income and the amount that a family would be eligible for. I should talk briefly about some federal rules that people still ask us about and might still play a role. Let's go on to the CARES Act. So the CARES Act is it's a leftover, right? You have to go back in the Wayback Memory machine of the beginning of the pandemic. The CARES Act was the first major piece of legislation, very bipartisan at the federal level. Again, at that time, the Senate was Republican, the US Senate was Republican, the House was controlled by Democrats, and the president was President Trump, a Republican. And this was the first of the stimulus payments that I think you might remember. Some went to people, some went to businesses. There were a lot of other components to the CARES Act. One of the key components from our perspective is it banned evictions in CARES Act eligible buildings through July 25th of 2020. And again, this was passed in the spring. And so it was a fairly forward thinking, hey, let's just not allow any evictions in quite a few buildings throughout the country until July 25th. Now, July 25th, 2020. So we're talking about, what is that, 15 months ago. A long time ago. But the reason why we're still talking about that is that there was a requirement as part of the CARES Act that once we hit July 25th, 2020, if a landlord in a CARES Act covered building wanted to file an eviction for non-payment of rent, just for that reason, non-payment of rent, then they had to give a 30-day warning. And it talked about the sort of similar stuff that is in the Minnesota requirement of notice. This part, this 30-day requirement, never sunsetted. That's a kind of legislative speak for it didn't have a specific end date. The ban on evictions had a very specific end date, July 25th, and that was not extended. It wasn't extended. But the 30-day notice requirement was never sunsetted, and it's never been legislatively changed or by any kind of executive order. I'm not even sure an executive order would solve that here. If President Biden said, I want to get rid of this 30-day notice requirement right now, this was legislation that was agreed upon by the federal, by Congress and signed by the president at the time. So it might take something similar to end this, unless some court decides that it's not legal somehow, which I guess could happen, but I haven't seen anybody challenge that yet to that meaningful level. So who's covered by the CARES Act? Well, any building that has a federal subsidy, pretty much of any type. And there's a very broad umbrella definition used in the CARES Act, which is, hey, if this is covered by the Violence Against Women Act, and there's a very broad definition of the Violence Against Women Act, what it covers, then it's covered under the CARES Act as well. Also, any building where the landlord has a federally backed mortgage, and that's a lot of buildings. Fannie Mae, Freddie Mac is the programs that you'd see there. They are going to be required to meet this 30-day CARES Act notice requirement. So a landlord trying to file an eviction for non-payment of rent right now may have to give, they certainly have to give a 15-day notice up through October 12th, but they may also have to give a 30-day notice under the CARES Act requirement. Additionally, I don't have this on the screen, but there's a couple of cities that during the pandemic have passed pre-filing notice requirements. Minneapolis has a 14-day notice requirement for non-payment of rent eviction, and St. Louis Park, a suburb of Minneapolis, has a 7-day notice requirement. So a landlord wanting to file an eviction right now, I have given landlord speeches my entire career. I don't know how many I've given, probably a couple hundred now. One of the things I'm asked frequently is, do I have to hire an attorney to file an eviction? And my answer has traditionally been, well, look, if you're not a corporation, you're just, renting out a place under your own name, there's a good chance that throughout the entire state, you could file a non-payment of rent eviction on your own and probably figure it out. Right now, there's a lot more to it. There just is. And so I'm not sure I'd give that same advice to a mom and pop landlord saying, hey, we need to go file an eviction. We want to make sure we do it right. Do we need a lawyer? Right now, I'd probably say it's worth hiring a lawyer to make sure you're meeting all the notice requirements that are still out there. As more rights are reaccumulated by landlords, we fast forward in time to July of 2022. Maybe it won't be as important for a landlord to do that. But anyhow, the CARES Act is something that might still play a role even past June 30th or June 1st of next year. The last thing I'll mention is the now historical CDC federal moratorium on evictions. It's no longer active. I'm bringing it up because people still ask us about it. I had a tenant Monday tell me about how she had sent something called a declaration of eligibility under the CDC to her landlord. And I had to explain to her that, that's been stricken by the Supreme Court, that no longer plays any role at all. The CDC moratorium never really did play much of a role in Minnesota. It always deferred explicitly to stronger protections that the state might have. So if the state had more protection in place, then the CDC moratorium said, we'll back off and not be involved. So, and the Supreme Court struck it. The Supreme Court said that basically if Congress passed something like the CDC moratorium, they'd probably take a slightly different view. I'm not exactly sure that they would take a different view of that based on how the votes went and some of the phrasing that was in the decision that we got, which wasn't really a decision. It was kind of a half decision. Supreme Court takes cases in strange ways sometimes these days, what people refer to as a shadow docket versus the sort of traditional docket where there's kind of a lot of buildup before cases happen. This was one of the cases that they heard in a real hurry and voted against the CDC. So the CDC federal moratorium on evictions, which was to go through October 4th, I think it was October 4th, is no longer in place. You might still hear some news about it, but it has no real impact in Minnesota. Okay, I think that's about a half an hour. That's the stuff I wanted to make sure I could cover. So let's jump into questions.
Water there, and Rachel will take the first question. So I got to bring those up here. Okay, so we did get a few questions sent in advance, and so we'll go to those really quick, and then we'll jump to the questions that are in the queue. So again, please feel free to submit your question, again, preferably in the question and answer Q&A system over Zoom. And we've got until 3 o'clock if we need to. This was submitted in advance. Somebody asking, appears they are staying in a hotel. Can the hotel I'm staying at just knock on my door and demand that I leave?
I mean, I guess it would need to know a little bit more. In general, probably not. If this is like a long-term stay hotel, or if this is, your residence, if this is where you are living, you are arguably a tenant. You are exchanging money for the right to be there, the possession of this particular space for a certain length of time. And so a landlord needs to have a reason, especially to ask you to leave, some sort of lease violation, if there are rules in place, like non-smoking room, non-smoking room might be one of them. In a hotel, I think that's usually pretty straightforward, whether a room is supposed to be non-smoking or not. But yeah, even without, as Mike was saying, without Minnesota, for the most part, having a notice requirement, the landlord still needs to have a valid reason to either terminate a lease early if you are on some sort of lease where it's a time frame, or even if it's, say it's after October 12th and your landlord just doesn't want to renew your term anymore, they still have to give you some sort of notice. Minnesota law would require it to be at least one rental period. So I know in hotel stays, that's often a very vague timeline, necessarily like, a more standard living situation of an apartment. Often you'll have a 1-year lease or month-to-month lease, that sort of thing. And so there's a couple of variables. I would recommend, if you are a tenant and that's the situation you're in, that you give us a call on the hotline. But in general, you can't just be told, to have someone knock on your door and be like, you need to get out, unless like the building's on fire. Like, then you should probably get out. But
Yeah, I'll jump in. I mean, you did mention this, but I'll stress that hotels have different rules than rentals do. What Rachel's really talking about here is if the hotel is basically a rental for the tenant, that it's become the tenant's home. And she mentioned extended stay hotels. It can sort of transform whether it's an extended stay or not. If the tenant kind of moves in there and they're there a long time, they're getting mail there, they're paying rent, weekly or even monthly. Some tenants will do that. Then at some point, a landlord-tenant relationship kind of gets formed, even though it's not officially what it's called. But she's the absolute most important thing she said is the tenant should call us directly on our free hotline, because it's very case specific.
Yep, and the number and our email and attorney website is up on the screen. So please give us a call. This next question is a little bit lengthy. Do you think you want me to?
I think you just try to summarize it if you can.
Okay.
Yeah.
So the question that came in, somebody has non-paying, so a landlord has non-paying tenants that are 15 plus months behind on rent. Their lease has expired, so they're on a month-to-month basis. The landlord's attorney sent a letter to the non-paying tenant at the beginning of September, basically saying you're delinquent on rent, you've not paid the utility bill, you need to contact us by a certain date in early September. If you do not respond, I assume you don't have any intent to come current on rent or utility obligations. And then, the landlord will proceed with eviction or some other action. Please be advised there'll be inspectors coming. Let's see here. So is that sort of notice saying you need to pay, you have to contact me by September 8th, so that maybe is less than 15-day notice. Is that sort of letter appropriate to send right now? Or does it need to be something that is sent after October 12th, the next phase?
Yeah, so I mean, I looked at the letter. My first thought was, okay, does this comply with the 15-day notice requirement? If this is all the letter includes. And I don't really think it does, not based on what I'm looking at. Maybe there's more to it. But we've seen a lot of 15-day notice requirements, and most of them are quite, I mean, there's a lot of white on the paper. There's just not that many words written down. They fill in some forms, basically. You owe X. Be you advised that as of this date, we are now allowed to file an eviction. The eviction moratorium is over. Here are the numbers to apply. I mean, so it's not a long sort of lawyer enhanced phrasing. It's actually typically very form looking kind of approach. I don't think that this is a 15-day notice, at least based on the information that we have here. But the question seems to be is, can the landlord get in trouble for having given this letter? Well, I guess maybe. It depends on what you define by trouble. We did have during the pandemic, during the peacetime emergency, where if a landlord was leaning on a tenant in a way that they couldn't, or threatening an eviction, or threatening a lockout or something like that, the Attorney General's office could step in, and there were sanctions that were pretty substantial against the landlord. Those are gone. The AG's involvement in a case like this would be not as explicitly stated, certainly, as it was during the peacetime emergency. And I think that's where this question is really coming from, is can I get fined somehow for giving this letter? I think, let's say that the landlord's lawyer runs down and files an eviction right now. The tenant is hopefully going to say, hey, I don't know that this is a 15-day notice requirement. It doesn't look like it to me, and that might be a defense. So the landlord will get penalized in a way. Their case could get dismissed. Maybe they hired that attorney to file the case, and so they paid the attorney, I don't know, $700 or whatever. So maybe they're out $1,000. So there's a penalty. It's just not as explicitly stated anywhere as before. But I don't really know what this letter accomplishes from a landlord's perspective, other than intimidation based on not a lot of footing legally, because the landlord either has the right to do this and they should give the 15-day notice, or they don't have the right to do it at this point. So there you go.
All right. We'll jump to some of the questions we got live here. So Wendy asks, if a tenant owes utilities and included the utilities, that utility portion in their rental assistance application, should it be argued that that's rolled in as part of the rent for purposes of the moratorium phase out? Do we know if any courts have considered whether a tenant can be evicted for material lease violation for overdue utilities when an application is pending for utility assistance?
This is complicated in that it's happening in real time right now. So I have seen evictions filed that are citing that a non-payment of utilities is a material lease violation, and that is what they are filing an eviction for. Whether that is going to work or not is, most of those cases haven't been decided yet. They're still waiting to be heard. There are, if a lease explicitly calls out that non-payment of utilities is a material lease violation, there's still the hurdle of, is it, does having the utilities get to the heart of the purpose of the lease? I guess it depends on the utility. Like, would not paying the internet be a material lease violation versus not paying like electrical or water? Might be much stronger case to say that that's a material lease violation if it's been shut off. That's the question as well, as, are we just not payment? Is this, are we gotten to the point of shutoffs? A lot of it is dependent on what the lease says and what the obligations of the tenant are. as far as whether those folks who have applied for utility assistance along with rental assistance, whether they should be considered for eviction or not for non-payment. Again, I think it's going to fall down to, who's responsible according to the lease for those payments. And is it something that is rolled into the rent that the landlord is charging, or is it something that's separate from the rent? So that's something that's being, I guess, worked out right now in real time. And it's probably going to be different from court to court and case to case. So I don't have a clear answer on this one, unfortunately.
Yeah, this question isn't something we thought about much pre-pandemic. Not really, and it's hard to put a percentage on the number of leases that have a clause that says if you don't keep these utilities current, it's a material violation. I mean, I've certainly seen it, but it is not in every lease. There's no way it's in every lease. I don't know what percentage, but I'm guessing less than half of the leases in Minnesota is it that explicit that this would be a material violation. And you have to have that. If you want to make that argument as a landlord, you have to at least have that in the lease saying that not paying the gas bill is a lease violation. If that's not there, then it's not a material violation. So the lease, just like Rachel said, the lease is sort of the start and in some ways the end of the question. Although the tenant would still have some arguments, yeah.
Mm-hmm.
All right, and moving on to the next question.
And before you read it, Eric, we do only have a handful of questions. We have about 45 minutes left. We are fine with ending early. That's no big deal to us. But if you do have a question that you've been thinking, oh, I can never get my question answered, today's the day to type it in. We have plenty of time.
Yeah. And I was going to mention just one thing, I guess, off the last one. It's slightly related. There's a comment into the Minnesota Public Utility Commission asking for them to state that the pending application there with Rent Help MN for utility assistance, that would be a protection against disconnection. So that's sort of a pending thing, but there's people considering that fairly soon. We got a question in the chat. I want to quickly jump to. This was earlier when you were talking, I think, about what's allowed under the moratorium, or sorry, the phase out. So here's the timeline again. Can they serve a notice if you have a pending application for Rent Help MN?
So I'm not exactly sure what the question is getting at. This is the one from Donna, I think, right, Eric, that you're reading?
That came when you were talking about the phases.
Right. So the protection that a tenant gets for the pending application stops an eviction from being initiated or proceeding. It doesn't explicitly stop a notice, which is different than an eviction, but a notice on its own doesn't mean much. I mean, okay, I gave my tenant a notice to vacate by tomorrow, and I gave it to him 2 days ago. Does that mean anything? Well, yeah, it's a notice, but does it have any real legal effect? What do I do if the tenant doesn't leave by tomorrow? Do I go file an eviction on the next day saying, hey, I have the right to evict? So I'm not sure if the question is asking, okay, once October 12th rolls around, if I give a notice, but they have a pending application, what if I'm not doing it for non-payment of rent? I'm not exactly sure if that's where they're headed with this. But that's a hard sell if the landlord has been sending tenant emails every week saying, where's my rent? Where's my rent? Or they hired a lawyer to send a letter prematurely saying, pay up or else we're going to look into whatever evictions we can file. And then suddenly they're giving a notice to vacate for no reason at all, is maybe a tough sale for the referee to buy or the judge to buy going forward at that point. But yeah, if the landlord gave a notice saying, you know what, you owe rent, so I'm giving you a notice because you owe rent, that one's a clear loser for the landlord if there's an application pending. That one seems clear to me. But other than that, we can't know exactly what a court would do with a generic notice given once October 12th rolls around. We haven't gotten to that point yet.
All right. Kay has a question. What other programs would protect a tenant if they have a pending application with them?
Okay, so the programs listed are explicitly at least protected under the off-ramp, are the programs that are defined in the statute or the session law, excuse me, as the gosh, I can only remember the acronyms, the ERA and the SARA funding. It's like
Generally known as ERA 1 and ERA 2 by the Treasury Department.
yeah, and so basically those are the two federal programs that were passed in December and then January of, and the programs that we're aware of are the Rent Help Amen program, the Zero Balance program, and that Ramsey County program. Some tribes also got funding and are distributing that through their own process. But those are the four kind of pools that I'm aware of.
Yeah, and there's I think any tribal government, which there are, I think 11 in Minnesota, had the opportunity to get funding. And there is a list of those on the National Low Income Housing Coalition's website. If you go to this link, I'll put it in the chat. Oops, I put that other one in the wrong area. But this link will get you to a chart where you can just type in Minnesota and it'll give you the programs that are available, which include those tribal entities. Okay, the next question, what are the citations for the city ordinances requiring a notice before eviction?
And I think Eric was going to post these. You know what, I think I mentioned this earlier. I've been here a long time. There was a time when I had virtually every landlord-tenant statute, at least the citation, memorized in the late 90s. But then they decided, because landlord-tenant statutes used to be in two separate chapters, they decided to consolidate them and codify them. And they rewrote them to some extent, some of them, but they renumbered every statute. So there's no statute that existed pre-1999 in landlord-tenant world that is still the exact same site as it was before. In fact, if you look up the Minnesota statute chapter, you'll see that it looks like every statute was born in 1999 or later. And that's just not true. Many of them are 100 years old, if not older. And so I stopped memorizing citations in the late 90s. And computers have made it pretty easy to just cut and paste. I do have, I don't know, 10 that I know off the top of my head. But other than that, I don't commit the numbers to memory. So thank you, Eric, for posting the answer. It's a long, whining explanation. Sorry about that.
It's like
recodification.
Yeah. It's like you were defending yourself from some allegation that none of us, hey, you don't have that memorized, Mike? Okay.
I used to think I should, but now I'm just like, recodification.
Really what this was just to get out of answering a question. And so I had to answer two in a row.
All right. Ayana has a question here. They are in Minneapolis. So I would have 14 days to file an eviction, or do I need to give a 30-day notice? So maybe Ayana is a landlord asking about how many days to give notice. Okay.
I mean, so the 30-day notice, at least right now that's in place, is for CARES Act covered properties that Mike went through during the presentation. So the 30-day notice is really going to be dependent on whether you are in a CARES Act covered property. So the ones that are federally backed mortgages, anything covered by the VAWA. There's a couple other ones in there that are pretty specific. The NLIHC, thank you, Eric, that search is a good place to start to try and determine if you are a landlord, whether that CARES Act applies to your rental property or not. The 14-day notice for Minneapolis applies to non-payment of rent evictions. And has to be given for at least 14 days prior to an eviction being filed. In this case, there's also if you're filing a non-payment of rent eviction, you still have to comply with the 15-day notice that the state has in place for non-payment of rent. So giving that 30-day notice, if you comply with all the requirements that the city and the state also have, you can probably roll them into one, but if you are a CARES Act covered property, you do need to give a 30-day notice before filing an eviction.
To know what kind of property you have and where you're located, because there's different rules. All right, Emma has a question here. Maybe a little bit similar. If a landlord issues a 30-day notice to vacate that includes a warning stating that an eviction will be filed by X date if the unit isn't vacated, does that officially fulfill the 15-day eviction warning requirement, or must the eviction notice be issued separately?
So just like the last question, we have some confusion about when does the 30-day notice play a role? When does the 15-day notice play a role? So I think what Emma is referring to with her 30-day notice is kind of a traditional 30-day notice to vacate, which actually is a little bit misnamed, and I don't blame Emma. A lot of people call it that. I think what she's saying is kind of a month's notice. So if the landlord gives a 30-day month's notice, do they have to give the 15-day notice? If she's talking about the CARES Act requirement, then maybe it would be sufficient, although I doubt it, because the CARES Act, I don't think, had any language that you had to say that an eviction could be filed at this time. Maybe it did, but Minnesota does have that requirement. It also has the specific reference to Rent Help Minnesota and the other agencies that where the money's available. So I doubt that a 15-day I can file an eviction if you don't pay notice, which a landlord can give and must give between now and October 12th if they want to file a non-payment or rent eviction in Minnesota, would comply with the CARES Act 30-day notice. You'd probably need to give two separate notices. And if the other alternative is that this is simply a non-renewal type notice given by the landlord, first of all, it's not just 30 days, it's a full rental periods notice, which is different than 30 days. That almost certainly would not comply with the 15-day notice requirement, would be my best guess without seeing the two documents. Eric, you're muted still, or we can't hear you.
Yep. Am
There
I
you
good
are.
now? So we got one question in the queue here, so we're gonna take a quick pause and just remind folks we've got about a half an hour, so happy to answer more questions. But
I could talk about recodification some more.
well, let's get to Amber's question first before you do that. But
Sure.
I might just use my administrator powers here and mute you if you do. Just a reminder of our upcoming webinar. Our upcoming webinars that we have going in the next few weeks, every week on Wednesday. Again, next week we will have, as Mike said, Hennepin County is the most populous and dense renter county in the state. So Referee Hotelling, who leads up the housing court in the 4th Judicial District, is a key important player on what's going on with evictions in the state and in Hennepin County. And so the referee will be on next week, next Wednesday afternoon, and talk a little bit about how Hennepin County is handling these cases. And then the following week, we'll have Dan Hilton from Housing Link on to talk about rental market trends during the pandemic. And then into October there, we'll be chatting on the 13th of October about the most recent change that occurs on October 12th that we've been talking a little bit about today. So jumping back to Amber's question here, a little bit of a detour on this legal question. Is a landlord's rejection of a physician's note for an emotional support animal valid if it was rejected because the physician advertises ESA consultations? The physician is licensed in Minnesota.
So this is a slightly divergent question, but this is good stuff to be talking about too, because this is a new law that Amber is referencing that was just passed this last legislative session. It's going to be 504B.113. But basically, the legislature went into effect on August 1st. And what the legislature is trying to do is define who can basically say that a tenant needs an emotional support animal. I think what they were trying to do is restrict tenants who were trying to just print off documents from online that didn't necessarily come from a space of like a medical practitioner or someone who was telling, they were just printing things off to try and get around having to pay like rent pet fees or something like that. So the new statute defines what a licensed professional is, and who can essentially approve or say that a tenant needs this emotional support animal. Judging from what, so it's rejected because the physician advertises ESA consultations. I mean, so the licensed professional just needs to be a provider of care who is licensed by the Board of Medical Practice, a physician's assistant, a nurse, a psychologist, a mental health professional, a social worker, a counselor, or one of those professions who holds a valid license in the other state, provided the professional has an existing treatment relationship with the tenant that's making the request. So I would say, based off what we're seeing, I mean, if the physician is licensed and they have some sort of relationship with the tenant, then it's not likely that that would hold up, but we don't know yet. You know, that there's been no cases regarding this. It's brand new. It hasn't been on the books even 2 months. And so we are, as we are with the phase out laws and stuff, we are in uncharted territory as it comes to how courts are going to decide how to interpret this law, and whether someone who advertises ESA consultations would be someone who would be allowable under the law or not. My guess is fine, but
I think knowing a little bit about the kind of the creation of this law and who was behind it, what they were really getting at was these online, as you mentioned, places where they would actually have medical professionals, but they were, I think the definition or the kind of label they had was ESA letter mills, basically, that they would never actually treat the patient. They'd have a licensed professional in some other state that would just generate a letter with a 5-minute consultation in exchange for $100 or something like that. I think that's what landlords were alleging. And so I think the key statute, or part of the statute that you're referring, 504B.113, is the statute, which it's not easy to find. I mean, Eric did put it in the chat, but it doesn't show up in the regular chapter. You have to click in a different part. But there's a portion that says that a licensed professional does not include any person who operates primarily to provide certification for a service or support animal. So the question that we got was about advertising. And I think if a judge is looking at the question plus the statute, they have to decide, all right, is somebody advertising, does that mean that they are primarily providing certification for service or support animals? Now, I don't know exactly what the word primarily is going to mean. Full disclosure, I am not a fan of this law. I never was. I think it's trying to modify / explain federal law. And so there's a real question about whether it can even do that. Just because a state law exists doesn't mean that it's upholdable if it's challenged. And I don't know what primarily means here. Does it mean that's all they do? Does it mean that's the first thing they do and the most important thing they do? And you could look up the dictionary definition of primarily. But that's, I think, really what the question is getting at. I think the mere fact that somebody advertises it, I don't think that that kicks you straight into that's my primary role. That's the primary service that I offer my patients. I think you'd have to have quite a bit more. So if this is all there was, I would absolutely recommend that the tenant file a complaint with the Department of Human Rights, alleging that the landlord didn't even comply with this statute, much less the federal law. So I don't know, but Rachel's absolutely right. This came into play, it came into existence meaningfully on August 1st. We haven't seen any cases. I don't know of any that have been filed. Maybe some have been filed, I'm not sure. But nothing meaningfully interpreting what this statute should mean. But I think it comes down to what does the word primarily mean? And that's kind of the kind of thing that lawyers argue about with lawyer papers and arguments. Lawyer papers.
Papers.
Documents. I remember one time
Business documents.
I had to get
Yeah.
business documents.
That's a fun story.
All right. Well, that's all the Q&A that I'm seeing right now. So unless you have any other questions, we can end today's webinar a little bit earlier. Again, there's our upcoming schedule, and you can visit our website to get more resources. And again, we did have a number of, I think, sort of detailed questions, particularly from folks that are tenants. So please do contact our tenant hotline directly if you have. We try to provide, the general information and about the situation, phase out situation on these seminars, but when the details matter, so renters in Minnesota, please give us a call.
There was a question asking if this is going to be posted, the recording of this.
Yes, the answer
From
to that.
Don as well.
Yeah.
No, but you know what? We still have a few people. I want to share the business document story. It's fascinating.
No.
Yeah, I'm going to tell it. It's good stuff. So
I'm going to turn the recording off. Then.
No, you're not.
Recorded
It's
for
It's
posterity.
a fun story. It's a fun story. Yeah, so our office had moved from one physical location to another, and we needed to change a bank account to reflect the new location of our office. Or something like that. We had to add some people to the account or whatever. We had to do some banking things. And we drove to our bank, Eric and I, and the former executive director, Beth, in a car on I want to say an August afternoon where the air conditioning wasn't working. And one of the windows didn't work too, I think. So it was really hot. We're going to this bank and we're sweaty and kind of miserable on the way there. And it turned out that this bank couldn't do what we needed. We had to go to a different bank. So we went to this different bank and they couldn't do what we needed. And so at this point, we decided, well, we should call before we drive to any other banks because this is miserable driving around. And so Beth called this next bank in this sort of heat wave stupor. And all she was able to get out in her question was, her question to the bank, when the bank answered the phone, hello, this is the bank. And she says, do you have business documents? That was her question. Do you have business documents? Which they smartly, trying to drum up business, answered, yes, we have business documents. There was no more detail involved in that than business documents, which was enough to get us to the place. I haven't thought about that phrase, business documents, in several years. So thank you for reminding me of that, Eric.
That was delightful. Thank you.
All right. Well, we're definitely not setting aside future weeks to have comedy 10 minutes. So appreciate that there's still folks watching, but yes, we will. We have recorded this for posterity and it will be on our website on that link within a day or two. And again, thank you for joining us today. And please do consider joining us in the next couple of weeks when we have some excellent guest speakers on. And thank you to both Mike and Rachel for hosting us today. So I'll shut her off then. Thanks.
Bye.